Good morning. It is Tuesday, August 29, 2017, and the hearing board of the South Coast Air Quality Management District is in session. We are meeting, it is a little after 9 o'clock a.m. in the morning in Diamond Bar at the hearing board room. And we have only one matter on the calendar for today, and that is Universal City Studios, case number 4935-15 for a short variance. So I'm going to call that case. And who is representing Universal City Studios this morning?
Good morning, members of the board. My name is Andrea Warren. I'm with Alston & Bird, representing the petitioner Universal Studios.
Can I ask you to, I'm sorry, repeat that, but turn on your microphone. Thank you. We keep an audio record of all the proceedings.
Good morning, members of the board. My name is Andrea Warren. I'm with Alston & Bird, and I am here representing the petitioner Universal Studios.
Thank you. And Ms. Warren, would you mind just spelling your name for the record?
Of course, it's Andrea space Warren.
Thank you. And for the district today?
Karen Manwaring on behalf of the executive officer.
Thank you, Ms. Manwaring. This case was asked or requested to be put on the consent calendar. We are here today because under our rules, a hearing board member has the ability to ask for the matter to come off of the consent calendar and to call a hearing. I'm going to start with just some preliminaries, and that is we received the stipulation to place the matter on consent calendar, but I'm not going to mark that since it was taken off. But there are a couple of documents I would like to mark, and that is first, we received a declaration of Joseph Bellis, C. Bellis, in support of the petition for short variance, and I'm going to mark that as exhibit number 1 and place that in evidence since the parties have agreed to do so. And to make sure that there are no objections, but I assume.
No objections.
Okay, and
No
not from the
objections
district.
from the district.
Thank you. And second, I'm going to mark as exhibit number 2, since it seems to be coming from Alston & Bird, the proposed findings and decision of the hearing board and proposed order. Mark that as exhibit number 2. And I'm just going to ask for a short opening. I don't know, Ms. Warren, if you were able to hear what happened at the consent hearing, but the senator asked for the case to come off because he had one issue that had not been covered by the papers, and I'll let him ask questions, but did you have a chance to hear that hearing?
I did, yes, last week, and I can present a very brief opening statement. I believe the board is generally very familiar with Universal Studios' request for a variance and for the historical request for a variance that they have asked for over the years to support their Halloween Horror Nights event. We believe that we have submitted the testimony that can support the 6 required findings to make the variance, to approve the variance, and we are here today and ready to present the testimony live if the board members have any specific questions. We have Mr. Joe Bellis. He is the Vice President of Corporate Environmental Affairs, and Ms. Amy Kuhl, who is the Senior Director of Environmental Health and Safety. And we understand that the specific question from last week concerned the complaints previously received by Universal Studios during previous events and the potential for indemnification by the district. And we understand that that issue of liability and indemnification is not part of the 6 required findings to make the variance, and also a condition related to indemnity and liability would be beyond the board's authority to impose those conditions under the provisions provided under the Health and Safety Code. So we see that as a separate issue that would not be a part of the grant of this variance. And we are here to answer other specific questions, but otherwise we are prepared to rest on the testimony that we've already provided.
Thank you for that opening. Ms. Manwaring, do you have any opening?
Yes, good morning, Chairman Prusak, members of the board. As you know, the district originally agreed to stipulate to the consent calendar because we do believe the 6 findings can be made, especially with Exhibit 1 and Exhibit 2 now in evidence. The district has no objections to that. Senator Holden, thank you for the concern that you raised. The district is comfortable based on the statutory structure, plus the indemnities and immunities that are provided, that immunities and indemnities provided by statute give the district comfort, and we are seeking no additional conditions at this time. Thank you.
Thank you. I'm going to at this time ask any potential witnesses to stand to take the oath, and then if there are any questions, we can ask the witnesses. If you don't mind rising. Please raise your right hand. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God? I do. Thank you. Okay, at this time, Senator, do you have questions for either? Well, let's start with Mr. Bellis. And before you have questions, let me ask Ms. Warren if you can introduce Mr. Bellis and ask him to spell his name for the record and just indicate that he took the oath.
Absolutely. Please state your name and spell your name for the record.
My name is Joseph Bellis, Bellas.
And have you been administered the oath?
Yes, I have.
And what is your title, Mr. Bellis?
Director of Corporate Environmental Affairs for NBC Universal.
Thank you very much. Senator, questions?
In the district, you mentioned indemnity by statute. Explain that, and how does that being indemnification relates to this case?
Senator Holden, as Ms. Warren mentioned in her opening, the 6 findings can be made on the paper, so if that is relevant to one of the findings, the district could provide additional testimony.
Thank you. Actually, I was going to thank you, Ms. Mary Moring. Senator, if you can explain how the question of indemnity would factor into your consideration of any of the 6 findings that we must make for a variance, that would be appreciated.
The 6 findings may, at this time, I'm not saying that it do not, you are, include an indemnification in the case that once given the variance and their physical, emotional problems as specified already in this petition, sharing the information with the district about the people who have been complaining about health problems associated with the Halloween event. My question to Ms. Warren is that although it was explained in the petition that during the event no one has mentioned a severe health problem, subsequent to the event, has anyone filed a claim relating to any incident that occurred during this Halloween night?
Let me interrupt for 2 reasons. Number one, any factual issues should be addressed to the witnesses that have taken the oath. But can you be more specific, Senator, which of the 6 findings is indemnification specific to your decision? The first finding being a violation of law, which I think the declaration of Mr. Bellis is clear. It's of the opacity rules. The second being beyond reasonable control. I'm not sure if indemnification fits within that or any taking of property. The third one being the balancing of any closing or taking of property versus the benefit in reducing air contaminants, a corresponding benefit. So any excess emissions or harm versus the harm of without a variance to Universal. The next finding being the consideration of curtailment in lieu of a variance, and the last 2 being monitoring and reducing excess emissions to the greatest or maximum extent feasible. I don't believe indemnification comes into play in any of those findings, but if I'm wrong, if you can explain that.
If any of those findings are subsequently violated and not complied with, then of course, and the lawsuit results from those variances from the findings, then my question would be whether or not, because we granted the variance, whether or not the district be implicated in the subsequent legal litigation that may or may not occur under those circumstances.
Let me ask you to, if I rephrase that for you, and because there cannot be a violation of findings. Findings are what we need to make in order to determine whether a variance should or should not be granted. However, a variance contains conditions. Is it that you are feeling, or is it your position, that a violation of the proposed conditions would lead to a indemnification or some issue where there'd be liability by the district? And if so, can you point to the proposed condition?
The proposed condition would be that when you, all right. Repeat the couple of those findings again for me, please.
The 6 findings?
Yes.
Let me draw your attention to, do you have the help?
Oh, yeah, okay, go ahead.
Oh, there we go.
And number 5, number 6, monitoring, that's fine. But during the time you monitoring the variance is in effect, it still has a relationship with finding number 5 to say during the period the variance is in effect, that the applicant will reduce excess emission to the maximum extent feasible. That's number 5. However, in the petition, the maximum extent possible, they're saying they would shut it down, they would cut it off. That's after all the events have taken place. But during the event, it's been reported that some people were overcome by the excessive fog, the machine, that some people were ill, this in that petition. And that being the case, and in each case they claim, and I'm sure they have, reported these incidents, these problems that occurred during this period to the district. Did the district take any further action at that point to discontinue the operation? I don't believe so. And if that being the case, then to what extent is the district liable or would be liable if a lawsuit should emanate from this variance was not adhered to? Okay.
I'm not sure, I still am not sure I'm understanding how it's related to the 6 findings, but perhaps you'd like to ask the witness questions about, to further explain how any excess emissions are being reduced to the maximum extent feasible and how complaints are being handled. And perhaps that would help the situation, Senator? Would that be?
Yes, please do.
Sure, of course. I can first ask Mr. Bellis to describe how the machines are used and how the emissions can be reduced to the maximum extent feasible.
Thank you. Yes. So the machines are installed in the maze, and they are set to operate on a cycle where there is a certain amount of ground fog generated. So it's not 100% fog, but just enough to create sort of that eerie, scary feeling inside of the maze. So not enough fog, and you don't have any kind of a sort of that ground fog kind of experience, and too much fog you just can't see. And so on an ongoing basis, those machines, all the machines are monitored, so that is just the proper amount of effect that's being provided. Because
Have you have any evidence where the visitors or doing this recreation have complained about excess fog and a problem resulted from it? It's part of your petition,
I believe one of the complaints that I recall seeing, there was, they had expressed an opinion that there was too much fog. But I mean, we have trained experts out there running those machines, and the creative people are out there in the, you know, at the event and during the planning of event to determine what is the optimum amount of fog to achieve the effect that we are looking for.
In the petition, I think you outlined a situation where one of the operators, employees who operating the machine, was overcome by fog and had to be taken care of. One of the employees.
That may be better. Amy, maybe
Ms.
better?
Ms. Cool can also speak to the complaint process. If you could speak to how customers generally can submit complaints as well as employees and what Universal has done to respond to those complaints that are
I'm
received.
going to, since usually we deal with one witness and then move to the next, but given that we are really dealing with a single issue, I'm going to allow to switch, but if we can introduce in the same way, the second witness, name, spelling, your title, and whether you took the oath today. And then if you want to address, just be clear on the record who is speaking.
Thank you. Absolutely. Ms. Cool, could you please state your name for the record?
Yes, good morning. My name is Amy Kool. It is A-I-M-E-E, last name Kool, K-O-O-L.
And did you take the oath this morning?
Yes, I did.
And what is your position?
My title is Senior Director of Environmental Health and Safety for the theme park and City Walk business.
Thank you. Senator, you had a question?
I asked a question already, and it was referred to Ms. Cool, who would be the person who's likely to answer it. So, did you hear the question?
Yes, I did. As to the question on someone being overcome by fog, one of our employees, I have no knowledge of that occurring. I actually am responsible for keeping track of all of our employee injury and illness records pursuant to the OSHA regulations, and we did not have a technician overcome with fog during our event.
How long have you been employed in this position?
I've worked for Universal Studios since 1992.
Well, it's been listed in the petition that one employee was overcome by fog intensity.
I don't believe that's what it says, but if you can point for Ms. Cool to where you're finding that in the record.
I read it, so I didn't underline it. I'm sorry. You have it?
I believe what you're referring to is on page 7 of Mr. Bellis's declaration in paragraph number 9 at line 11, where it says a Universal Studios employee complained that his allergies were triggered by the fog. Is that not it?
That's on
I'm sorry, that is in,
5 of the petition.
I'm sorry, that is in it is in Exhibit 2, the findings and decision of the hearing board and proposed order. My apologies. On page 7 of that document, paragraph number 9, again, line 11 and 12, a Universal Studios employee complained that his allergies were triggered by the fog, and Universal Studios modified the fog machines where the employee was stationed at that time.
Right, that's true. And it also shows on page 5 of the petition that paragraph 1, 2, 3, 4, Universal Studio received 6 complaints relating to the fog, including 1 complaint from the employee. One event guest complained that the event had too much fog, had a bad smell, and the list goes on as you explained in your petition. Have you received any complaints subsequent to the event from visitors to the park?
Complaints regarding the event?
Yeah, regarding the fog, excessive fog.
I am not aware of that, Amy.
No, and I can speak to our complaint process if that helps. We have a system where all of our guest complaints are funneled into our guest relations department. They come in various forms. So someone, if they're at the park, they can walk into the guest relations office and file a complaint. They can contact us online. We have a call center that is monitored by team members of the guest relations department. So any type of complaint that comes in is tracked and logged in our system. And we actually have alerts that go out for keyword events. So if a fog complaint came in, I would actually get alerted to that, and then I would report that to our environmental team, who would in turn report it to the district. We also, at that time, give the guest the phone number to call in themselves to report to the AQMD.
To your knowledge, there's been no litigation resulting from any of these incidents that you specified in your petition?
I'm not aware of any litigation associated with fog, no.
Let me ask you another question. Any of you can answer. Whether or not did the district contribute to these people having these problems specified in your petition?
I'm going to object to that question.
I'm going to sustain that objection. I'm not sure, first of all, I don't believe that's a very clear question, and second of all, I don't see the relevance of that question at all.
It's relevant to the extent it relates to the issue that I raised before, indemnification.
Indemnification, it has been, I think at this point, we should probably cut off any discussion of indemnification. Both parties have taken the position indemnification is not relevant. Both parties have said they're not relevant to the 6 findings. I have not heard any kind of argument that they are relevant to the 6 findings, and we've heard the petitioner, Universal City Studios, say that they are not inclined to include indemnification provisions in any, so at this point, I don't believe there's any other questions to be asked about indemnification.
Your point is well made. However, in the real world, if it turns out that condition number 5 is violated.
Condition number 5. That's
Okay.
not a condition. Are you talking about the 6 findings?
6 findings.
That is not a condition of any variance that would be granted. That is a finding that we simply need to be making based on the evidence that has been presented. And let me stop there and just ask Ms. Cool or Mr. Bellis. Number 1, is it correct, as is stated, Mr. Bellis, in your declaration on page 3, paragraph number 10, that the fluid that is used in the fog machine, based on a commissioned study, is the safest available in the industry?
That is correct.
Okay. And Mr. Bellis, can you further confirm, or either Mr. Bellis or Ms. Cool, if you can confirm for us approximately how many thousands of visitors you had in 2016, and then the number of complaints that were received in 2016 related to fog?
Obviously that is a highly sensitive business confidential piece of information, but we're willing to say in the hundreds of thousands of people.
And how many complaints?
6.
6.
And over the last 5 years, we've probably seen a nearly doubling of the attendance. And so we do have more people coming to the event. The events are longer. And so...
Thank you. Is there any other questions we can ask from a factual nature, keeping in mind that any discussion of indemnification at this point, I think, is more properly handled by deliberation?
Thank you. My next question is that when you start using this mixture in order to create fog?
This particular mixture or this type of fog fluid?
This particular mixture.
I don't recall exactly when the fog fluids mixtures change with vendors over time, but the basic propylene glycol fog fluid has been in effect as long as I've been around for 15, 20 years. That basic technology has been around. And that's generally considered the safest and less risky fogged type of fluid to use for this type of application. You know, there are mineral fogs, oils that are used, and they're much more of an irritant than these are. I mean, this glycol type of fog is the same material that's in the vaping cigarettes.
Prior to using this combination of mixture, what other mixture did you use prior to using this one in order to generate fog?
Each of the vendors have their own proprietary mixture, but it's essentially the same technology of a glycol mixture.
Universal Studio had their own type mixture?
No, each of the vendors. We buy the fog fluid from a vendor, and the vendors will vary the fog mixture over time. So I mean, the specifics of how long we've used this and how long you know, this mixture has been in exactly these proportions, I couldn't say at this point. But the basic technology, the basic ability for this material to cause irritation wouldn't be, in my opinion, marketably different over time. It is basically the same technology, the same kind of material.
What action have you taken when there's been a complaint on site that you have excessive fog permeating the area? What action do you take?
I mean, the basic reaction is to go back and look at the fog machines and make sure that they're operating properly, and that they're being applied in the way that the creative people that design the mazes intend. That we have the proper opacity within each of the mazes. I can let Ms. Kuhl answer the guest procedure, the guest response procedures.
If we receive a complaint on an event night, we have a technician that is just there to monitor the fog machines, inspect them, check them. They go through frequently and check all of them. So we would respond that technician to the specific area of the complaint. And to Joe's point, they would inspect the unit, make sure it's running properly, not emitting more than it should be, it hasn't been kicked or something in the course of the event, and they would make adjustments at that point if necessary.
When there's been a complaint of excessive fog, is it suspected that the emission is in excess? And if so, what do you do to make the adjustment?
The technician would make the adjustment. They're all set to a level, so they actually can't really move outside of that range. We have had, I think one of the complaints in particular is actually referring to a show quality complaint. It's that they couldn't see the props in the mazes well, not that it was an irritant or bothering them from a health perspective.
At the point you have a complaint, is it just arbitrary, or do you determine that there's been excess emission? And if so, how do you do that?
The technician that is trained to operate the unit.
Okay, have you had excessive emission before?
Only in this one that I'm aware of. I mean, they do adjust them from a show quality perspective. The scenic art director is there every night, and weather conditions can change how the fog sits, how it drifts. So if we have a fog that, that it appears to be masking the maze too much and people can't actually see all the artwork, they'll turn it down from a show quality perspective.
You have 60 machines that's operating?
I'm not sure of the exact number. I believe
60, sir?
That's the intended amount. It can vary less than that, but no more than that.
Okay. What is determined based on a complaint that the fog is excessive? You have to make adjustments. And when that's determined, do you report the excess emission to the district?
If someone complains about it, then we report that to the district pursuant to the variance.
I see in the petition that you share with the district that there have been complaints, but you don't say they're due to excessive emission.
That's not always the complaint. Generally, I don't think the public would say we're complaining due to excessive emission. I believe it's usually a complaint about.
What they're complaining about is that it's too much fog. Then that means that it's been excessive or not excessive?
The question is opacity, and the variance is to essentially violate district rules in the Health and Safety Code for opacity, not excess emissions in terms of any emission limit.
In terms of our emission limit, the way that we would look at it is 180 gallons a day, or per event, times 60 machines. And so that would be our determination if there is an excess emission, because those are the conditions in the variance.
And that would be the correct way that it would be calculated under our rules.
In your opinion, looking at condition 5 again, you discuss the
Condition?
emission levels to the maximum extent, reducing it, extent feasible, define that, it's open-ended.
As far as the extent feasible, the amount of fog that we apply in the maze is what our art directors believe is the correct amount to create the effect that we are looking for. If there is less than that, then it would not be creating the effect that we are looking to achieve. And so and too much, I mean, it's a fine line, and like Ms. Kuhl had suggested, we will be looking at the operation of these machines on a real-time basis, because the atmosphere, the temperature, the humidity all affect its performance. And so there are constantly people out there managing the operation of them so they create the proper effect. Not too much, not too little.
These machines, they have a maintenance program for them?
They're pretty simple machine. They take a fluid, they heat it up, and it gets blown out of a nozzle. They're small machines.
Senator, again, these are not machines that are malfunctioning, that we need to be concerned about the maintenance. The question here is it's knowing and intentional opacity violations.
All right, thank you, Madam President, Chairperson. For your information, I removed this issue of consent calendar, and because I had some of the questions that I'm raising today, I was not here when it was first approved by the hearing board. Pardon?
You voted for it last year.
And what I voted for is the same situation that it was in place for the past 4, 5, 6 years. And I assumed that my colleagues had looked at this thoroughly, and I'm sure that they did, before they gave approval. And I was concurring in the approval last year, as it occurred in the previous years, not knowing all the details of being in a position, because I was new in the job, to raise these questions that I'm not raising. But it's been, in my business, I've seen a lot of...
Senator, let me stop you there. Do you have any other questions for the witnesses? And then we can have this conversation as part of deliberation.
I think they've answered them all,
Okay.
Madam Chair.
Anyone else have any questions for any witnesses? Dr. Lerner.
When you received the complaint, they went to the complaint department or they emailed it in or however they communicated with you, was there any way of, was this an aberrant event? That is to say, was the fog level too high? Was the fog level too concentrated? Was there a greater opacity? Do you have any explanation for this, or are you saying that this just happens because hundreds of thousands of people pass through, and this is 5 or 6 people who became ill, and that's something that unfortunately can happen? I'm a physician, and I want to know if there's something that occurred during the process that triggered these people becoming ill. And you may not be able to answer that, but it's just an interesting question from a medical point of view.
And keep in mind, we do have the warning signs out there. So if you know, there are warning signs at the mazes that there is this fog material present. To my knowledge, I'm not aware of any operational variation that caused any of these complaints. I had always looked at it as simply the number of people going through there. And Ms. Kuhl can further respond to that.
Yes, I don't believe, I was just reviewing the complaints. I don't believe they were on the same night, so I'm not recalling any event or unique instance that caused these. Other than, I believe the employee that complained has a pre-existing medical condition that was exacerbated by the fog. So not because of the fog, he had a condition that he was more susceptible to being sensitive to it.
This question, follow-up. You said that there is a sign before people enter this area. What is can you just briefly, in a sentence or two, tell me the content of the sign?
Oh, it should be in the.
And maybe I missed it.
Can you read it? Warning: persons with medical sensitivity to fog effects should be aware of the park scare zone.
Thank you.
Any other questions before we close the hearing?
Yes, Madam Chair.
Senator?
In each of these situations where there's been a complaint, according to your petition, you refer those complaints, you notify the district that these complaints are on file. Why do you feel that it's so necessary that you notify the district? Is that one of the findings that require that you notify the district when there have been complaints?
That is a condition of the variance.
Really? That you notify the district when there's been a complaint?
Yes, it is a condition of the variance.
Those are findings that you're looking at.
Yeah, but you, in the petition, say, each complaint that's been reported, you notify the district.
Proposed condition number 6 on page 11 of Exhibit 2 states that petitioner shall immediately respond to any complaints. Petitioner shall also notify each, oh wait, am I looking at the wrong one?
The condition requiring notification of the district was in the
Yes, and shall promptly
requirements last
notify.
year
Yes, I'm sorry, it is
voted
the
on,
right one.
and it has been there ever since we have been issuing the variance each year.
Thank you, but will you repeat it again so far?
Sure.
And you might.
That condition was part of the conditions that you voted on last year. That condition has been in place each time we've granted a variance. It's been several years.
And it reads, petitioner shall immediately respond to any complaints received and shall promptly notify the district at 1-800-CUT-SMOG of any complaints. So that answers the question.
It's part of the requirement. Okay, good to know. In doing so, the district been put on notice, and when they put on notice, has the district taken any action to determine whether or not there's been any violation in the condition?
Not that I am aware of. I am not aware of any inspection or follow-up from the district on these complaints.
You repeat, no inspection, no follow-up from the district?
Correct.
When the complaints have been shared with the district?
That is correct.
That's the problem.
Any other questions? Ms. Byrd?
I just wanted to confirm for the record that all the 5 complaints, I'm just going to go through them just for the record. That one person complained of much fog, bad smell, and his brother coughed. Another customer stated his daughter had anxiety, which was not a cough or reaction, it was anxiety, and said there was too much fog. Another said they waited in line too long, and then they had an asthma reaction as a result of waiting in line for too long. And another is kind of vague, says that she and her mother did not feel well. So, and this was, as you stated, over the course of the entire period, not in the same night. So even if complaints were submitted to the district, they would have been submitted as on different occasions at different times. And all of these actually are not, well, you could say they're health related, but they weren't anything that would, I don't know if you could say it's just the fog to just say, I don't feel well, but that was reported, so.
We have viewed the order rather broadly, so that any complaint that has any element of fog into it, we felt obligated that we should be reporting it.
And that's appropriate in your understanding. And I would take that understanding as well. I was just reviewing the fact that they were not all specifically a result of inhaling this fog.
At this time, I'm going to ask Ms. Warren if you have any closing statement you'd like to make.
We have nothing further to add. I would just say again that we believe that the evidence to support the 6 required findings to make the variance finding have been submitted in our written testimony and also supported by our live testimony as well today. And that's how we would close.
Thank you. Ms. Manwaring, if you have any closing.
The district waives closing. Thank you for your time.
Thank you. Is there any member of the public who wishes to be heard? Seeing none, then I will start the discussion. Board members, this is a case that, as we've stated, we've heard, I think every year since I've been on the board, and possibly before that. And I just wanted to start by saying the use of this fog, as I understand it from the evidence that we receive each year, and certainly no exception from the declarations we received this year, is very common theatrical fog. It is, after a review, the safest type of fog that is available. And yet Universal Studios seems to be the only petitioner that comes before, or facility that comes before us, and every year follows the appropriate channels of requesting a variance from this hearing board. And that alone is appreciated. On top of that, every new board member, including myself, who comes on the board, puts Universal through the ringer and says, does this belong on consent? Is this something that the 6 findings can be made? It's something that they're voluntarily undertaking. And every year, something new is asked of Universal, including, I believe I may have been the one who asked several years ago, that Universal asked the district board, not this board, for a change to the rule. And diligently, Universal has followed up on that, which always leads me to the beyond reasonable control finding, which I'll go through, because that has been refused by the district with good reason, but they have followed that. We have asked that complaints be reported so that the district can keep very good track of essentially if anyone really is being affected. We have asked for sheets on the composition of the fog in order to be sure and be clear that this fog is not inherently hazardous for people to breathe in. So I wanted to just start the discussion by saying that this petitioner has been very diligent in following up on the things that have inevitably plagued various new board members. So with that, I believe I certainly can make the findings. Beginning with the violation, again, this is a question of opacity. And it is due to the fog machines, approximately 60, we heard today, sometimes less, depending upon what is needed in a given evening, to create an atmosphere for this particular Halloween happening. And it is of the District Rule 401B1B and Health and Safety Code Section 41701 with regard to the opacity of the fog that is being created. I believe that it is due to conditions beyond the reasonable, again, go back to the word reasonable control of the petitioner. The petitioner is trying to create an event that is obviously very attractive to people, and that people are voluntarily undertaking. And to make the event that it is, these type of fog effects are necessary, otherwise the event would not be quite the same. Also, on top of that, as I mentioned before, the district does not make any exception in its rules for this type of theatrical violation of the opacity rules. We're not talking about a breakdown in a refinery with opacity of smoke being above a certain amount. We're talking about something that people voluntarily undertake, and it's reasonable and beyond the reasonable control because the district has refused to change the rules, understandably so, because that would open the door to many other things that would be unintended. I do also believe that it would be an arbitrary, unreasonable taking of property because without the fog, the event certainly would not be as successful and perhaps could not even take place. And I think I've mentioned in the past, I've actually attended the event, and I would have to concur that it definitely adds to it. The taking would be without a corresponding benefit in reducing air contaminants. Again, the composition of this fog is generally accepted in the industry, the theatrical industry. We have seen the chemical sheets, and the understanding is that it's the safest available. Also, I would definitely add to it the number of complaints, and Ms. Bird further elucidated that it's not essentially 6 complaints about harm to people from breathing in the smoke, but very few, less than a handful of complaints for thousands, and as we heard today, perhaps hundreds of thousands each year who visit, versus the ability to put on this type of production. And again, I go back to the fact that it's really a voluntary undertaking. People want to come because they want to have a particular experience, and so the effects are quite small, and so that balancing is an easy one for me. Curtailing operations, they are agreeing to reduce it to the use to only the amount that they need and to the effects that they need in order to make it the experience they desire to make it. And to curtail further would again simply mean that it would not occur. And I don't think the balancing calls for that. Reducing excess emissions to the maximum extent feasible. The only evidence we have on that is, again, to reduce it to the maximum amount that is needed to achieve the effect, but no higher than that. And to limit it to the times and days and amounts of time that are specified in the proposed order. And there are conditions in the order to monitor the use of the fluid that goes through the fog machines. So I can make all the findings. Is there anyone else who would like to add to the discussion? And I should probably say again, I agree that indemnity doesn't factor into any of the findings as I see them, or the discussion as I see it today. Really, we're just trying to determine whether or not to give a variance or to grant a limited type of variance for the use of something that will cause opacity. Anyone else?
Thank you, Madam Chair,
Oh,
for your explanation, and I'm more informed now than I was before. However, I still have some concerns that I think we should consider, if not this time, in the future. For example, it says here in condition number 6 that if requested to do so, the district, the quantify emission levels from the source. Quantify means you are going to be more specific by documenting. That's what it says. When you quantify emission levels, then you say, if requested to do so by the district, and report these emission levels to the district pursuant to a schedule. The fact is that if you have emission levels and you know that and it's determined that you exceeded those emission levels, then you have to quantify and report those to the district if the district requests to do so. I've not heard any testimony where the district has requested any additional information from the petitioner when it's been reported to the district that those emission levels may have been violated by complaints.
May I respond to that? First of all, again, that is a finding we need to make, which I believe I can make, with regard to monitoring or quantifying emission levels. In addition, the page 11 of Exhibit 2, conditions 4 and 5 have to do with restriction on the total gallons of fog fluid that may be used per 2-day event. And number 5, petitioner shall keep records of the amount of fog fluid used on each date, which are made available to the district. And so the monitoring finding, number 6, is satisfied as far as I'm concerned. And regarding the level of emissions, again, this is a question of opacity. This is not a question of quantifiable emissions, for example, where there's a NOx limitation of 5 parts per million, and we have before us a petitioner who's asking to emit 10 parts per million. We're discussing a fact that the variance is to ask to go over those opacity limits. So in every event, they will be going over the opacity limits. The complaints are not related to how far they're going over that. Rather, a particular handful of people have lodged complaints according to the evidence that they have been sensitive, either coughing or a pre-existing asthmatic condition has been triggered, et cetera.
All right, I once again reiterate the reason why I raised my questions, because it's required that the petitioner report to the district every complaint that's levied at that particular time. Number 2, not assuming that litigation will occur, but it's likely if it were to occur, they would file a complaint against the petitioner, and anybody else they could decide is responsible for the problem that the person is having. And when they look at the condition 5 and 6, that would implicate the district, in my view. So that's the reason why, that's in my view.
Those are findings.
I'm sorry, I keep in finding in 5 and 6, it would clearly implicate the district, and they would become a doe. And that being the case, they figure we deep pockets, that could happen. That is a likelihood, not them saying that it will occur, but that is likely to occur. If there should be a complaint that ends up being litigated, they're going to go through everything with a fine-tooth comb. And 5 and 6, if we have not adhered to those findings, then of course that could be a case, in my view. Anyway, that's the reason why I raised these issues. I'm glad to hear that the Madam Chair had some concerns when she first entertained voting for Universal Studio. And so I'm new on the job. And whereas last year I just rubber stamped what my colleagues had done previously, trusting that they looked through it with a fine-tooth comb and made the right decision. And I didn't have all the background information to raise the points then as I've raised today. With all the number of people visiting that site, hundreds and thousands of them at any time period, and I was there myself the other night, and you got 5 or 6 complaints. That's pretty good track record. However, I raised the question because it only takes one to cause the trouble that I think would come from this facility. But anyway, that's where we stand.
Thank you, Senator. The last statement I want to make on the indemnification issue, just the last thing I'll say about the issue. I'm satisfied, as Ms. Manwaring stated, that legally government agencies such as the district is indemnified under the law from being subject to lawsuits for something that a variance has been granted. But regardless, I want to say that the reason why it is important to note that it is not relevant to the 6 findings is because whenever a facility comes before us and we can make the 6 findings, then it is our duty to grant a variance because they have put forth their proof, they have put forth their evidence as the California legislature has asked them to do. For us to say that we might be afraid that someone might sue the district if we grant a variance is just not a consideration that we should be making. It's not fair, and it means that we're not doing our job as we're required to do by the Health and Safety Code, and that has been invested in us. So it's my feeling that it should not come into play, as is not specifically stated in our 6 findings. Ms. Byrd.
I just wanted to add a couple things to your findings, Ms. Prusak, and that was the material safety data sheet that is attached to the petition. On the last page, you can see the health risk or the health hazard that's considered, and it says 0. And I just wanted to make that statement. I also wanted to say that for number 2, finding number 2, that this is an opportunity, in my view, of balancing whether or not compliance would result in a practical closing. This facility is potentially able to make $6 to $7 million, according to their petition, and as well as employ for this period of time 1,400 employees, and I think that's significant in this area. Even though it's temporary employment, it is still employment. So I just wanted to make those points.
Thank you, Mr. Camarena.
This board issues hundreds of variances a year that allow excess emissions for a limited period of time under specified conditions. I don't understand why the senator has not raised this issue before. It's no different.
I'm going to just stop for 1 second. Ms. Byrd, you mentioned attachment 4 to the petition. And so at this time, given that this is part of the deliberation and part of our findings and decision, I'm just going to stop and ask the parties if they wish both what is already marked as Exhibit 3 and Exhibit 4, which have to do with the safety of the fog that is being, or the materials that are being used for the fog, should be, if you have any objection to it being put into evidence.
The petitioner has no objection to those being added as exhibits.
Ms. Manwaring?
The district has no objection to the petition and all the exhibits coming into evidence.
Okay. Then I'm just going to, we already marked Exhibit 1 and Exhibit 2. I'd like to mark Exhibit 3 and 4 as they, actually, let's make the petition Exhibit 3, and the others will just be attachments to that exhibit. So that way we can mark it as in evidence. Senator?
In response to Mr. Camarena, in the cases where I voted for variances, there have been requirements that we have subsequent follow-up source testing, status reports, etc. And so therefore, in this particular case, that is not a requirement. So in some of those cases, that's the reason why I concurred. And very often, as you know, I already voted no a lot. So the vote's been 4-1, and for various reasons. But, you know, everybody vote according to what their beliefs are, based on the evidence as they see it, and I support what they do when they do it, because that's part of the process. Sometime, as we say where I used to work, you love it to death. You put everything in the action, in the event, in the petition, and then you can still vote against it because you're concerned about accountability. We do things for different reasons, and I appreciate you even making a statement.
Ms. Berg.
Condition 5 of the proposed conditions does address the issue of fog use, and records should be made available to the district, as well as the petitioner will submit, or the petitioner shall submit, a written summary to the district at the expiration of the variance. So that is covered, Senator, as far as follow-up to what was done in this variance, in the conditions of the variance.
One final statement, Ms. Chair.
Yes, Senator.
On page 2,
Of
number 11, I just want
the
to read.
petition, are you talking about of the petition?
Yeah. It says that, or any other equipment or activities at this location currently or within the last 6 months. This last 6 months of this petition, last 6 months, the fog machine, the Halloween was not occurring. So in the past year, then there could be a problem. In the past 6 months, it's not applicable because this fog machine was not operating in the past 6 months. Last 6 months ago, this is August, subtract 6 from that, that's the 8th month, that's February. So that question is no, and no is the reason why is because they don't have the fog machine in operation.
And the point of that is?
It says last 6 months under variance coverage. So this is
Yes,
not, that was
and-
not in that variance coverage then.
They answered the question as asked honestly. Is there,
Pardon?
they answered the question as asked honestly in the petition. Did you, was there a point you
They
wanted to
just
raise
said
about it?
no.
Because they were not under variance in the last 6 months.
Correct.
Okay. If there are no further comments, Dr. Lerner?
I can support the findings. I just want to make one comment because it might be applicable, and you all have to talk to other medical people and your legal team. The warning with medical sensitivity to fog effects. For many of these people, it may be the first time they are exposed to a chemical fog effect as opposed to being out in Santa Monica on a foggy morning. You only have to take a few deep breaths if you are allergic, and one wouldn't know, and you could have an asthmatic attack, or you could start getting a runny nose or runny eyes. I think that it's perfectly reasonable what you're saying, but if you really want to cone down on this, you might want to say something in the order of medical sensitivity to respiratory or pulmonary problems, something along that effect. You might consider that, because I think that will protect everybody. It will protect your customers. It will protect Universal. So everybody benefits by just rephrasing the sign to be a little bit more general, okay? Because I could walk in there and I have asthma for years. Play tennis, I get asthma. Go skiing, I play asthma. So I don't play tennis or go skiing. But I will have a problem next fall, next winter, if I did go skiing, because I do have that problem at altitude. But otherwise, I'm fine. And you don't know this. And I just want to point that out. It's just a medical thing. And your people who are smarter than I am about how to word this can word it in a more general way just to protect the public and protect yourselves.
Thank you, Dr. Lerner. I'm going to, Senator?
It sounds reasonable to me, what the doctor just stated regarding protecting one's health. Should that be included as a requirement at all?
No, I don't believe so. We don't have enough evidence to show that there is a true danger to the public, and that is a completely different legal issue that I believe that Universal City Studios has to work out with its own legal team. But I do believe that the suggestion by the doctor is a really good one, and I'm sure was heard by Universal. So with that, I'm going to offer a motion in the matter of Universal City Studios LLC, case number 4935-15. I move that we grant the requested short variance and that we adopt Exhibit number 2, which is the proposed findings and decision of the hearing board, which has all of the relevant information necessary in it, including the schedule of events and the time through which this short variance would take effect. What is the last date? Last event is on November 6, 2017. So it would be between now and, no, not between now. What's the first? Between the first event, which is September 8th, and the last event, which is November 6, 2017. And it would be from the rules that are listed 401B1B and 41701 with regard to opacity for the not more than 60 fog machines that are to be used as specified in Exhibit 2 and the proposed findings and decision of the hearing board at the Universal Studios lot, which is, the address should be specified. Yes, 100 Universal City Plaza, Universal City, California. That is the location of the event. And I further move that we adopt the findings and decision of the hearing board with the following changes and additions. On the first page on line 18, we insert the date, today's date, August 29th, 2017. It's the date it was heard. I further move that we amend line 21 to insert after the word petitioner, was represented. So petitioner was represented by Andrea S. Warren, comma, attorney at law, and that we remove the comma and the words did not appear. Also on that same line, we insert after respondent executive officer, the word was represented by, and include Ms. Karen Manwaring's name, and then delete comma did not appear. I'm going to delete the joint stipulation to place the matter on consent calendar. Wait. Sorry. Going back to line 17, this petition for short variance was heard. I will delete on the hearing board's consent calendar. So it will just read, this petition for a short variance was heard on August 29th, 2017 pursuant to notice and in accordance with the provisions of California Health and Safety Code, Section 40825. And then as amended, that showing that the parties were represented and were present, and then deleting the joint stipulation to place the matter on consent calendar. And just to state, the declaration of Joseph C. Bellis and the proposed findings and decision were received at evidence. Period. Thank you. And deleting and the case submitted. Okay, I don't think there's any other changes there. And that is all the changes that I propose. The excess emissions are of opacity and so to be determined. And that concludes my motion. Is there a second?
Second.
Thank you, Dr. Lerner. Any discussion on the motion? Mr. Camarena? No. Ms. Byrd? Okay. Mr. Camarena, how do you vote?
Yes.
Ms. Byrd, how do you vote?
Yes.
Senator, how do you vote? The motion passes 5-0, and thank you very much for appearing today and for your further testimony. Good luck. Are there any other matters, board members? Thank you. We are adjourned for the day.